trying times when our nation is so divided, the only thing that can bring us all together is kicking one of the two presidential candidates off the ballot. Yes, that'll do it. Now our nation can heal.
God bless America.
Yes, a few months ago I told you that there was a possibility that Donald Trump would be ruled ineligible for the presidency because of Section 3 of the 14th Amendment. And now one state has actually booted him from the ballot. On December 19th, 3 years to the day after Donald Trump sent this infamous tweet announcing a mass protest, "Be there, it will be wild," the Colorado Supreme Court held that Trump is disqualified from holding the office of president because he participated in an insurrection. As a result, the court ruled that Trump cannot be listed on the Republican presidential primary ballot in Colorado. This decision opens up a big can of worms for the embattled U.S. Supreme Court. Will it overrule the Colorado Supreme Court? How will it structure its decision? What precedent might this set for other states? And of course, what's also going on with Michigan and Maine as Trump gets kicked off another ballot? Today, we're going to talk about the ramifications of this decision. But first, what in the world just happened in Colorado? Well, in October, a group of Colorado electors eligible to vote in the Republican presidential primary, including both registered Republican and unaffiliated voters, filed a petition in the district court for the county of Denver, asking the court to rule that the former President Trump may not appear on the Colorado Republican presidential primary ballot. The plaintiffs asserted that he, quote, was ineligible under Section 3 because he engaged in an insurrection on January 6, 2021, after swearing an oath as president to support the U.S. Constitution. The district court conducted a 5-day trial and then found by clear and convincing evidence that Trump engaged in an insurrection, as those terms are used in Section 3 of the 14th Amendment. However, the district court concluded Section 3 does not apply to the president because the presidency is not in office and therefore the president is not an officer of the United States. The plaintiffs appealed and the Colorado Supreme Court partially overturned the district court decision, finding that Trump committed insurrection and that he was an officer of the United States. The first issue was whether the state had jurisdiction to decide whether a presidential candidate had participated in an insurrection and was therefore disqualified from the ballot. Now, you might legitimately wonder why in the world we would want 50 different standards for how an election is administered. Well, take that up with the Founding Fathers. Since the Constitution delegates to the states the authority to prescribe the times, places, and manner of holding congressional elections, the states retain the power to regulate their own elections. Now, I'm not going to do a deep dive into the applicable Colorado statutes because we have a lot of material related to the federal Constitution, and the Supreme Court's not going to care that much about the actual Colorado election law issues here. So let's move on to the text of Section 3 of the 14th Amendment to the federal Constitution, which reads, quote, "No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in an insurrection or rebellion against the same or given aid or comfort to the enemies thereof, but Congress may by a vote of 2/3 of each house remove such disability." Section 3 was added to the Constitution after the Civil War, when Northern Republicans were outraged at the prospect of Southerners who seceded from the Union returning to hold positions of power in the same government that they tried to destroy. This was their way of saying that if you ever participated in an insurrection in this country, you aren't eligible to serve as an officer of the United States. But they didn't define all the terms that they used in Section 3, so the court had to do it for them. So the Colorado courts first had to determine whether Trump had participated in an insurrection. When the 14th Amendment was ratified, there was an assumption that everyone knew what an insurrection looked like because there had just been a civil war. It seems that Congress would block anyone that it felt had participated in the Confederacy. But in the absence of a civil war, what are we to do? Well, the Colorado Supreme Court started with the dictionary definition of the word insurrection. Merriam-Webster says it's an act or instance of revolting against civil or political authority or against an established government, or an act or instance of rising up physically. And the court agreed that insurrection for purposes of Section 3 has to include a concerted and public use of force or threat of force by a group of people to hinder or prevent the U.S. government from taking the actions necessary to accomplish a peaceful transition of power in this country. And the Colorado courts concluded that whatever definition you're using, it would apply in this scenario. Right after January 6, Republicans quickly recognized that what had happened met the general definition of insurrection, just like their Reconstruction-era ancestors. Here's Majority Leader Mitch McConnell on January 7, 2021, using the same definition as the Colorado court.
It was a violent insurrection for the purpose of trying to prevent the peaceful transfer of power after a legitimately certified election from one administration to the next.
Trump's lawyers declined to offer a definition of insurrection, instead arguing that an insurrection is more than a riot, but less than a rebellion. The court agreed that, quote, an insurrection falls along a spectrum of related conduct, but no authority supports the position taken by President Trump's counsel at oral argument that insurrectionary conduct must involve a particular length of time or geographic location. The bottom line is that there has to be a group of people who use violence in a public way, and violence also has to be directed towards achieving some kind of public purpose. A private act or even a conspiracy to commit a crime doesn't rise to the level of insurrection, and the required force or threat of force doesn't require bloodshed, nor does it require those involved to be highly organized at the insurrection's inception. And you can see how this definition might include Trump's actions before and during January 6th.
Mike Pence is going to have to come through for us, and if he doesn't, that will be a sad day for our country.
Pence cave, we're going to drag through the streets. You politicians are going to get drugged through the streets.
And during the events of January 6th, the court said, quote, it is undisputed that a large group of people forcibly entered the Capitol and that this action was so formidable that law enforcement officials on site could not control it. The court slammed Team Trump for arguing that no one was armed on January 6th, since the mob was armed with a wide array of weapons.
The Oath Keepers stored a cache of weapons for a QRF, or quick reaction force, that would respond to the Capitol armed if President Trump were to, quote, declare an insurrection and to call us up as the militia.
Many of the rioters also stole objects from the building and even from the police, including metal rods, shields, and batons. And then the court considered whether Trump really engaged in an insurrection for purposes of Section 3, since Trump wasn't with the mob when they entered the Capitol building. There wasn't really much precedent, so the court looked at treason cases. In 1807, Chief Justice Marshall explained that, quote, all those who perform any part, however minute or however remote, from the scene of action and who actually lead in the general conspiracy are to be considered traitors. The Colorado court held that engaged in requires an overt act and voluntary act done with the intent of aiding or furthering the common unlawful purpose, and concluded that Trump engaged in an insurrection. Here the court notes that Trump laid the groundwork as early as August of 2020 when he said the election would be rigged against him. In September, he refused to commit to a peaceful transfer of power. The court emphasized that Trump and his supporters were united in the purpose of stopping Congress from certifying the election. Quote, the mob was coordinated and demonstrated a unity of purpose. They marched through the Capitol building, chanting in a manner that made clear that they were seeking to inflict violence against members of Congress and Vice President Pence. And upon breaching the Capitol, the mob immediately pursued its intended target, the certification of the presidential election, and reached the House and Senate chambers within minutes of entering the building. The mob achieved its objective, at least temporarily. Quote, this breach caused both the House and Senate to adjourn, halting the electoral certification process. In addition, much of the mob's ire, which included threats of physical violence, was directed at Vice President Pence, who, in his role as president of the Senate, was constitutionally tasked with carrying out the electoral count. In other words, the mob wasn't on a tourist trip taking selfies, as some Republicans have recently insisted. They wanted to stop the peaceful transfer of power. Now, if you ever get kicked off a ballot, then you'll need a good lawyer. But if you want a great lawyer, my firm, the Eagle team, can help. If you've been in a car crash, suffered from sexual harassment, or are dealing with Social Security or workers' comp issues, we can represent you or help find you the right attorney who can. It's so important to talk to an attorney right away so you don't lose your chance for a full recovery and maximize your options. So just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. The link is below. The Colorado Supreme Court agreed with the district court that Trump was no innocent bystander in these events. He recruited, quote, Proud Boys, the Oath Keepers, and the Three Percenters, QAnon conspiracy theorists, and white nationalists to travel to Washington, D.C. on January 6th. The court concluded that Trump was aware of and sanctioned violence. The court suggested that the mob never would have assembled if Trump had not invited them. Quote, at this point, the record established that President Trump's plan was that when Congress met to certify the election results on January 6th, Vice President Pence could reject the true electors who voted for President Biden and certify a slate of fake electors supporting President Trump, or he could return the slates to the states for further proceedings. Now, the Colorado Supreme Court overturned the lower court's decision that the president is not an officer of the United States. Now, the district court concluded that the presidency is not an office, civil or military, under the United States for two reasons. First, the court noted that the presidency is not specifically mentioned in Section 3, though senators, representatives, and presidential electors are. The court found it unlikely that the presidency would be included in a catch-all of any office, civil or military. Second, the court found it compelling that an earlier draft of the section specifically included the presidency, suggesting that the drafters intended intended to omit the presidency in the version that it passed. But the state Supreme Court concluded that the specifics of that change don't prove that there wasn't an intent to exclude the presidency from the covered offices. This part of the majority opinion focuses on the spirit of the law rather than the letter, because it concludes that it would have been logically absurd for Section 3's drafter to exclude the president from the list of people who shouldn't be allowed to hold elective office if they participated in an insurrection. Quote, the drafters of Section 3 were motivated by a sense of betrayal, that is, by the existence of a broken oath, not by the type of officer who broke it. All of us understand the meaning of the third section, Senator John Sherman stated. It includes those men who have once taken an oath of office to support the Constitution of the United States and have violated that oath in spirit by taking up arms against the government of the United States are to be deprived for a time at least of holding office. The majority opinion also makes a textual argument by finding that, quote, the Constitution refers to the presidency as an officer 25 times. The court also notes that the Constitution refers to the presidency as an office under the United States in several contexts that seem to support the conclusion that the presidency is such an office. And as another example, they cite the impeachment clause, which reads that Congress can impose, as a consequence of impeachment, a disqualification to hold and enjoy any office of honor, trust, or profit under the United States. If the presidency is not an office under the United States, then anyone impeached, including a president, could nonetheless go on to serve as president. This reading is nonsensical, as recent impeachments demonstrate. The court's point is that it would have been weird if the impeachment proceedings against Trump and Bill Clinton would have resulted in their removal from office and disqualification to hold any future office, except for the presidency. The Colorado court concluded that, quote, President Trump undertook all of these actions to aid and further a common unlawful purpose that he himself conceived and set in motion, prevent Congress from certifying the 2020 presidential election, and stop the peaceful transfer of power. The court held that Trump is barred from the primary ballot, although that decision is stayed through the Supreme Court's review. Now, all 7 of the Colorado justices were Democrats, and the result was 4 votes to 3. The 3 dissenting justices also raised substantive issues that may get the attention of the Supreme Court. Some of the dissenting justices said that the court didn't give Trump enough due process. Now, what constitutes sufficient due process to disqualify someone from the ballot? That's an open question. Should the person have the same safeguards they would in a criminal trial? Or should the process be more like a civil case? We don't really know. Here, in this particular case, there was a 5-day trial in the district court where both sides presented testimony, and the court came to a conclusion. Trump was represented and filed briefs outlining his position. The parties called witnesses, and many third parties filed supplemental amicus briefs to help the court decide. But on the other hand, the hearing lacked discovery. Neither side could subpoena documents or compel witnesses, and it was decided by a judge rather than a jury. The dissenting justices also said that maybe there should be an independent procedure, something akin to a criminal trial, before a court rules that a person can't appear on the ballot. The disqualification clause is frustratingly silent on whether there must be an independent proceeding, so the question is whether Section 3 is really self-executing. Now, a law is self-executing if it is immediately effective without further action, legislation, or legal steps. The Supreme Court has never decided this issue, but Chief Justice Solomon Chase opined on it while he was a circuit justice for Virginia. In 1854, Chase was going to preside over the treason trial of Jefferson Davis. Now, that trial never happened because President Andrew Johnson gave him a pardon. But Chase allegedly told Davis's lawyer that he viewed Section 3 as a criminal punishment, and that if Davis was disqualified, he would not face a criminal trial. Then in 1869, Chase decided a case called In re Griffin. Caesar Griffin had been sentenced to a 2-year prison sentence for assault by a state judge who happened to be a former Confederate officer. Griffin argued that the judge was disqualified under Section 3 and that it was self-executing. Justice Chase disagreed. Here he held that the legislation by Congress providing for removal was necessary to give effect to the prohibition of Section 3. And without such legislation, the judge was entitled to continue in his position. Now, remember when I said earlier about 50 states and 50 different rules? Well, the Michigan Supreme Court has ruled that Trump's candidacy was a political question, and Michigan law didn't give the Secretary of State the right to keep him off the ballot. But in Maine, the legislature delegated authority to determine candidate qualifications to the Secretary of State. So Maine voters filed 3 administrative challenges to Trump's presence on the primary ballot, and the Maine Secretary of State, Shenna Bellows, held a hearing where Trump's lawyers and the challengers argued the merits of disqualification. And Bellows has now ruled that Trump is ineligible to be listed on Maine's primary ballot. Now, the decision was made by the state official rather than a court, but the rationale is pretty similar to Colorado. Trump tried to prevent the peaceful transfer of power on January 6th. The riot was an insurrection, and Section 3 bars Trump from office. Bellows relied on the testimony of a historian who said that that some, quote, members of Congress believed the presidency was in office when the amendment was being debated, as did contemporaries outside of Congress, including those who sought to keep Jefferson Davis from the presidency. Therefore, Bellows found it, quote, implausible that the drafters of Section 3 chose to exempt the highest office in our government from an amendment designed to keep Confederates from positions of power. Bellows said, quote, I am mindful that no Secretary of State has ever deprived a presidential candidate of ballot access based on Section 3 of the 14th Amendment. I am also mindful, however, that no presidential candidate has ever before engaged in insurrection. The Maine decision is pitched directly at the Supreme Court's conservative wing, which has ruled that the court must prioritize the normal and ordinary usage of words rather than secret or technical meanings that would not have been known to the ordinary citizens in the founding generation. And as Bellows notes, that language comes from the District of Columbia versus Heller, where the court held that the Second Amendment guarantees an individual right to possess firearms independent of service in state militia. Now, it's almost certain that Trump will appeal that decision. So the question is, will the Supreme Court take these cases on? Well, that's pretty likely. While the Supreme Court has just recently turned down Jack Smith's request for hearing the immunity cases directly without waiting for the Court of Appeals, it's hard to picture that the Supreme Court would allow states' courts to have the final word on the meaning of Section 3 of the 14th Amendment. And most commentators are assuming that the court will overturn the rulings and let Trump run for president in one way or another. But the way they do it, it's going to be, of course, very fascinating. But you can also be certain that the court will claim that politics had nothing to do with their reasoning. And you can already see how this case is scrambling the normal political and legal valences that would exist in a case like this, with many Democrats using principles of originalism or textualism to look at the text and original intent of the 14th Amendment to disqualify Trump from the ballot, and also many Republicans explicitly bringing politics into things, saying that we should ignore the textual and original meaning of the 14th Amendment and look to the political ramifications. And constitutional law professor Steve Vladeck has summarized the political and legal ironies that this case brings up on the excellent It's Complicated podcast.
I realize this is a weird argument for a constitutional law professor to make, but these are weird times. I mean, I tweeted this Tuesday night and knew I was going to get in trouble for it and did. But I think you can believe at the same time that President Trump engaged in insurrection and that he ought to be disqualified from ever holding office again, and also believe, given the Republican Party's casual relationship with truth and facts and evidence and widespread endorsement of January 6th related and election related conspiracy theories, that it's actually better for our politics if Trump loses having been on the ballot in all 50 states than if he loses having been kept off the ballot in a handful of states by this, maybe correct Asha, but novel application of a constitutional provision that very few people had heard about before 2021. And so, I think what this really is, and I mean, you know this as well as anyone, is, the dirty little secret is that law is not an absolute, right? Law is part of a mush that politics is also part of. And I think that the Supreme Court probably was hoping against hope that they didn't get dragged into this mess. And that maybe the Colorado Supreme Court, like the Minnesota Supreme Court, found a way to not keep Trump off the ballot. And to me, the real headline of what happened on Tuesday is now I think the Supreme Court has to step in against, not wanting to, and in a way in which there's almost no, obvious win, right, for the Supreme Court.
Yeah, it's weird times in the world, and politicians are getting doxxed and swatted left and right, all for their political beliefs, which is terrible. Never swat someone. It's a felony. You'll go to jail. But it's possible because so much of your personal data, like your personal address, is online, which is why I use today's sponsor, Incogni. Incogni removes your personal data from online data brokers. They reach out and make sure it's taken down. If these data brokers object, which I've seen, Incogni will take care of that too. It's amazing. Now, I don't know if you've ever Googled yourself, but there are major people search sites out there that probably have your personal contact info too. It might be because of a data hack, but sometimes our friends and family even provide that info voluntarily by clicking on one of those boxes when they sign up for websites or apps. These sites provide in-depth records, including information such as home addresses, contact details, license plate numbers, family members, financial information, and even religious and political beliefs. These sites can expose you to a wide range of dangers, from scams to identity theft to online harassment and stalking. Now, it was very important for me that I not appear on those sites, and Incogni took that information down. And not only does Incogni help with your online personal info being taken down, but it can also stop marketing efforts. I've seen a huge reduction in the amount of spam emails that I get, spam calls, and spam texts. And it's no surprise why I was getting all of this spam. According to the 2022 annual data breach report by the Identity Theft Resource Center, the number of victims has gone up nearly 41% from 2021. I was constantly getting notified that my information was part of a data breach. So when that happens, Incogni fights for you to have your personal data taken down from data brokers. Believe me, so many people have it, tackling this yourself would be nearly impossible. But that's where Incogni comes in. Incogni fights on your behalf to remove your personal data from data brokers and deals with any objections from their side. All you have to do is create an account and give them approval to work on your behalf. Incogni conducts repeated ongoing removals because even if the brokers remove your data once, they can collect it again and then use it again. Incogni makes sure that your personal information stays off the market for good. And it was fascinating for me to look at my own dashboard and realize that I'm on hundreds of data brokers lists. Here's part of my personal Incogni dashboard. It shows that these 3 sites had data on me that was rated 10 out of 10 on Incogni's sensitivity scale. These brokers had data including my contacts, financial data, and health data. It was terrifying to see exactly how many brokers had my data, but it was really fun to watch Incogni get them to delete that info one by one. So if online privacy is important to you, give Incogni a try. You can click on the link below to get 60% off Incogni when you use the code LegalEagle. So again, to get an exclusive 60% off discount, just click on the link that's on screen or down in the description and use the code LegalEagle. After that, click on this link over here for more LegalEagle, or I'll see you in court.